Take it away whenever you're ready. Thank you.
Okay, thank you. Welcome, everyone. Welcome to Who Can Consent When the Subject Can't, Understanding Legally Authorized Representatives in the Context of Research. Some of you may have heard me give this talk in the past when we were able to do it face-to-face. Nothing has really changed. So if you've seen it before, it's the same basic presentation. So what we're going to talk about is who can consent on behalf of the subject and the circumstances under which they can consent, and who can consent for minors and under what circumstances, and when minors can consent for themselves. And then we're also going to talk briefly about what is excluded from the definition of experimentation under Florida law. So as many of you know, unless the IRB has approved a waiver of informed consent, an investigator may not involve a human being as a subject in research unless the investigator has obtained the legally effective informed consent of the subject or the subject's legally authorized representative. And what constitutes legally effective informed consent and who may act as the legally authorized representative is determined by state law. The common rule doesn't go into any detail on that. Also, there is no federal preemption, which means that the informed consent requirements contained in the common rule do not preempt any applicable federal, state, or local law, which require additional information to be disclosed in order for consent to be given. So the state of Florida could require additional elements be included in the consent form, and the common rule would not preempt that. I should mention too, if you have questions, maybe enter them in the chat and Lauren will let me know. In Florida, we have a patient's Bill of Rights and Responsibilities, and under that law, a patient has a right to know if medical treatment is for purposes of experimental research. They have the right to consent prior to participation in such research. They have the right to refuse to participate, and they have a right to participate on a voluntary basis regardless of their ability to pay. Legally effective informed consent is the process by which the IRB approved consent form is reviewed with the subject. Any questions are answered and signatures are obtained. But what happens if the subject can't consent to the research? Either they lack capacity, they have diminished decisional capacity, they're a minor, or they're unconscious. That's where legally authorized representatives come in. And under Florida law, we have five ways that individuals can act as legally authorized representatives. We have legal guardians, we have healthcare surrogates, and we have attorneys in fact. And then we'll also talk about minors as well. So legal guardians, they're generally created judicially, and they create a relationship between the ward, which in this case would be the patient or potential subject, and the guardian. And the court appoints that guardian to act on behalf of the ward's person, property, or both. And guardians can be appointed for both adults and for minors. They can serve as a guardian if they're a resident of the state and they have capacity, obviously, which means they have to also be 18 years of age or older. Any non-resident of the state who is related to the ward, the legally adopted child or adoptive parent, or the spouse can act as legal guardian. And professional guardians can also serve as legal guardians. But there are also exclusions for who can serve as legal guardian. Persons convicted of a felony, persons with a financial conflict of interest, banks, trust companies, and savings and loans may only act as guardians of the ward's property. So someone from the bank or trust company cannot make medical decisions or decisions to participate in research on behalf of the ward. Except in the case of minors, guardians of adults may only exercise those rights that have been removed from the ward and delegated to the guardian by a court. Again, it goes back to property versus person. So a court could determine that A person needs to have someone act on their behalf with regard to their property or their finances, but not necessarily their medical decisions. So the legal guardianship papers will lay out what decisions that guardian can make on behalf of the ward. Also, except in the case of minors, legal guardians may only consent to research if the individual has been delegated that authority by the court to make healthcare decisions on behalf of the ward. It goes back to what I was just saying. If the legal guardianship papers say that the guardian makes decisions, financial decisions, or property decisions, that does not mean that they have the authority to make healthcare decisions. Then we have healthcare surrogates and proxies. These are statutorily created, and they don't require a court's intervention. There's no difference in the decision of level, the level of decision making, only in how they are appointed. They can make healthcare decisions on behalf of the patient, including informed consent. They can refuse to consent or withdraw consent to any and all healthcare, including life-prolonging procedures, with some exceptions. And those exceptions are abortion, sterilization, electroshock therapy, psychosurgery, or experimental treatments that have not been approved by an IRB in accordance with the common rule. So what's the difference between healthcare surrogates and proxies? A healthcare surrogate is a competent adult who has been expressly designated in writing by the patient to make healthcare decisions on his or her behalf. A proxy, on the other hand, is a competent adult who has not been expressly designated by the patient to make healthcare decisions, but who is authorized under state law to do so, and we'll talk a little bit more about that. Also, a healthcare surrogate can continue to make this healthcare decisions on behalf of the patient, even after the court has appointed a guardian, unless the court modifies that authority or revokes it. But essentially, a proxy, once a court has appointed a legal guardian, they become the proxy for the individual. So proxies are designated in the following order by statute: judicially appointed guardians, spouses, adult children, parents, adult siblings, other adult relative, or close friend of the patient. When you're seeking a proxy consent on behalf of a potential research subject, these are not listed in order of convenience. In other words, if there is a judicially appointed guardian and a spouse, but that spouse is not the judicially appointed guardian, you have to go with the judicially appointed guardian. Also, if there is an adult child and a spouse, and the adult child is there with the patient, you can't skip over spouse. Spouse is the one who would provide the proxy signatures on behalf of the patient to participate in the research. Let me also say that if you are using a proxy to enroll a subject in research, you need to document the process and how you determined that, say, the spouse is the proxy for the subject. So in summary, surrogates and proxies may consent to participation in research on behalf of the subject if it is IRB approved, and it doesn't involve any of the prohibited procedures like electroshock therapy or abortion. Another individual who can often have authority to consent on behalf of the subject are attorneys in fact. An individual is appointed by a power of attorney to perform certain specified acts on behalf of another person, in this case, the principal or the patient/subject. And what you're looking for is a durable power of attorney. There are lots of powers of attorney granted. They could be granted, say someone is closing on a house and they are going to be in Europe. They can have a power of attorney to allow someone to represent them at the closing. But a durable power of attorney only comes into effect when the principal becomes incapacitated. With a regular power of attorney, that authority ends if the principal no longer has capacity. So you're looking for a durable power of attorney, which enables the attorney, in fact, to act in the event the principal becomes incapacitated. And again, in this case, the principal is the patient/subject. A durable power of attorney may specifically grant authority to the attorney, in fact, to make healthcare decisions on behalf of the principal. A lot of times you may see a durable power of attorney that allows the individual to act on behalf of the principal in matters of finances if that person becomes incapacitated. The durable power of attorney should specify that it also includes healthcare decisions. If there is a durable power of attorney and a healthcare advance directive, then the the terms of the healthcare advance directive control unless the durable power of attorney was executed after the advanced healthcare directive and expressly states otherwise. So if there is a durable power of attorney that has been executed, and then you also have a healthcare advance directive that may name someone else who is designated as the healthcare surrogate, then that person listed in the healthcare advance directive, if that was issued after the power of attorney, then that's the one that stands. Always, if you're in a sticky situation and you're not sure who has authority to consent on behalf of the patient/subject, you can contact the General Counsel's office. David Lewis is my successor in that role, and he can assist you with going over any papers that may have been presented to you and determining who has the authority. So in summary, attorneys, in fact, may only act on behalf of the patient when the specific authority to do so has been granted in a durable power of attorney, and there is no advanced healthcare directive in conflict with this authority. It's also important to note that if you have an incapacitated subject who regains capacity, whether they were unconscious and now they're conscious, his or her consent must be obtained in order to continue participation in the study, even if the study no longer involves interventions, but it continues to meet the definition of human subjects research. In other words, they should have the ability to decide whether all the data you collected on them while they were unconscious can still be used in the research going forward. Minors. So the common rule defines children as persons who have not attained the legal age for consent to treatments or procedures involved in the research under the applicable law of the jurisdiction in which the research will be conducted, which means Florida. If the research is being conducted here in Florida, then Florida law determines who is a minor and whether that minor can consent for his or herself. In Florida, minors are anyone under the age of 18. And those minors can consent to medical examination or treatment for STDs, including HIV testing, voluntary admission to a substance abuse treatment facility, and donating blood without compensation. So if a study were to involve an STD test, say you're creating a new assay to detect a sexually transmissible disease, the minor who is seeking that treatment can consent to participation in that research. Then we have emancipated minors, and emancipated minors assume most adult responsibilities before reaching the age of majority in their jurisdiction, which in Florida is 18. So they are no longer under the care and control of their parents, excuse me. And I say most adult responsibilities because there are different levels of emancipation. So minors can be emancipated by marriage, in which case they're fully emancipated. They can make any decision any 18-year-old or older person can make once they're married, even if they're 15 years old. They can be emancipated by court order, but that emancipation may be limited. A child star, for instance, may be emancipated for purposes of signing contracts for themselves, but they may not be fully emancipated for other things. Unwed and pregnant minors are emancipated, but only for purposes of consenting to medical or surgical procedures for herself or her child. And then if a minor is adjudicated as an adult, he or she is also emancipated, but only for purposes of consenting to healthcare services, not for research. So if you have a 17-year-old and you're doing research on prisoners, that prisoner is only adjudicated for purposes of making healthcare decisions, not for determining whether or not he or she will participate in research. Guardians of minors, just like with adults, guardians may serve as legally authorized representatives under the common rule, and it defers to state law on the matter of who can serve as a minor's guardian. So under Florida law, certain persons other than the minor's natural or adoptive parents or the minor's legal custodian or legal guardian can consent to medical care and treatment, and that is defined under Florida statute. So medical care and treatment is defined as ordinary and necessary medical and dental examination and treatment, but it doesn't include surgery, general anesthesia, psychotropic medications, or other extraordinary procedures. So a grandparent, for instance, could take their grandchild to a dental appointment to get their teeth cleaned and can consent to that. But the grandparent cannot consent to the use of general anesthesia in that minor. So persons who can consent for a minor in order of priority, not order of convenience, a person who possesses the power of attorney. So, and that power of attorney specifically states that individual can provide medical consent for the minor. So say you have two minors as children and you're going to go on vacation with your husband. You want to leave, you're leaving them in the care of your neighbor. You're very good friends, you trust your neighbor. So you provide a power of attorney to your neighbor in case something happens and your children need medical care in your absence. A step parent, a grandparent, an adult sibling, an adult aunt or uncle can also consent to the provision of ordinary medical treatment. Minors can consent to participation in research if it involves any of the treatments under which they can consent under Florida law. So again, the example of the STD assay that you're developing. Minors emancipated by marriage or court order, if the court order also includes that they can make decisions based on, healthcare decisions for themselves. Unwed pregnant minors, when the research involves treatment relating to their pregnancy, natural or adoptive parents, legal custodians or legal guardians, and individuals who possess a power of attorney or court order authorizing consent to participate in research. So going back to that example of you're going on vacation with your husband and you're leaving your children with your neighbor with a power of attorney, if that power of attorney doesn't specifically authorize that your neighbor can consent to, for the minor to participate in research, they don't have that power. I can't imagine why you would want to give them that power anyway. So who can't consent to research on behalf of a minor? Step parents, grandparents, adult siblings, adult aunts or uncles. Minors emancipated by pregnancy outside of marriage if the research does not involve treatment for which they can consent under Florida law. So if it's a treatment that has absolutely nothing to do with their pregnancy, they can't consent to it. The parent or legal guardian would have to consent to it. And minors emancipated by adjudication as an adult. I'm sure many of you are aware, the common rule requires that the IRB determine whether children in the study are capable of providing assent, whether assent should be required, whether it can be waived, or whether it's not necessary because the research holds out a prospect of direct benefit. I want to point something out. I get this a lot when I'm reviewing studies where the study involves both adults and children, and we're requesting that there be an assent for the child. And researchers often refer to it as consent. Minors can't consent only except in the circumstances that I just discussed. It is an assent rather than a consent. And the assent should not necessarily read like the consent form. So IRB 02 has templates based on the age of the children involved. We have a very short template for younger children and a longer one for older children who are capable of understanding more about the study. Those are assents and they should read that way. IRB 01, on the other hand, includes a signature area for assent of the minor. Should minors be consented upon reaching their majority? Florida law states that performing any procedure or prescribing any therapy, which by the prevailing standards of medical practice in the community would constitute experimentation, there's that word again, which we're going to talk about the exclusions to, on a human subject without first obtaining full, informed, and written consent constitutes grounds for disciplinary action. And this is in the statute on medical providers. OHRP also provides guidance on this topic, and they have indicated that unless the IRB approves a waiver of consent, the now adult subject should be consented to participate in the subject and the study, even if the study no longer involves interventions, but it continues to meet the definition of human subjects research. So if they were enrolled in a study as a minor, say a trial for a cancer drug, and they've now turned 18, but you're not doing any interventions anymore, but you're continuing to collect follow-up data on the minors who is now an adult. They need to consent to the continued collection of their information and the retention of their information. So experimentation, there is an exclusion from the definition under Florida law of experimentation, and they exclude the comparison of two or more approved therapies. So if you're comparing drug A and drug B, and both of them are approved, and both of them are standard of care, and you're just trying to see if one works better than the other, that's excluded from the definition of experimentation under Florida law. Also, emergency treatment that is the subject of FDA approved and IRB supervised research activities. Some of you may have conducted research, emergency research under FDA rules, which provides an exception for the informed consent requirements for emergency research when the IRB finds that certain requirements are met. It's a pretty extensive process to get this type of research approved in the community, but that's where Florida law comes in with that exception, because if it weren't for that exception, this wouldn't be able to be conducted in the state of Florida. But there are two important caveats to this exception. The treatment must be directly related to the patient's life-threatening condition, and it has to be administered under the direction of a physician licensed in Florida. And the treatment cannot circumvent any known advanced healthcare directive, living will, or DNR. So in conclusion, Florida law does permit certain individuals to give legally effective informed consent to participation in research if the subject is unable to do so. However, the authority to consent to medical treatment does not always translate to the authority to consent to research. So again, as I said before, when in doubt, ask. And the person you would want to contact under those circumstances is David Luce in the General Counsel's office. So if we have any questions, Lauren, please let me know.
Yeah, so it looks like we got one question so far. Is there an age at which a child can assent?
So this is left up basically to the IRB to determine, and the IRB has determined that age 7 and above, the child should be capable of assenting.
Are there any other questions? All right, what if the parent is present with a child who is 18 years old?
If then the child who is not a child at 18, the child would consent, the 18-year-old would consent. the parent no longer has authority to consent on behalf of the 18-year-old unless the 18-year-old lacks capacity in some way, shape, or form. If they have a cognitive or developmental disability, which prohibits them from having capacity to understand and assess the research risks and benefits, then the parent would consent, and in that case, they would have been appointed the legal guardian of the 18-year-old.
All right. For documentation purposes, we should have a copy of which legal documents in the event of an audit. How do you, can you tell us a bit more about documenting?
Yes. So if there's, the person is indicating that they are the legal guardian of the subject, then you would request to see the legal guardianship papers. And it should state that they have authority to make medical decisions on behalf of those individuals. Or the person may say, I have a power of attorney. You need to ensure that it's a durable power of attorney. Any questions, again, contact the general counsel's office. And copies of the documents are helpful. With a healthcare surrogate, that's usually also in writing, so you would want a copy of that documentation. Sometimes it's a separate document that has healthcare surrogate designation. Sometimes it's an advanced healthcare directive that lists, whether people want to receive extraordinary treatment and who can make those decisions. Proxies, there's not going to be any document because it's purely by statute. In which case you need to look at the list in order of priority as to who has authority to consent as a proxy for that individual. This is all somewhat complicated. Unfortunately, there's no black or white, decision making in this. So always feel free to contact the general counsel's office. They can help you.
So in terms of cognitive capacity, what is the best practice if you have an adult who is borderline?
Yeah, so I actually give a whole separate presentation on this, but especially if it involves a high-risk procedure, that could even be a cancer trial, or it can be a new Alzheimer's drug. You need to make a determination, a physician needs to make a determination of the subject's capacity. And this doesn't necessarily have to be a big hairy deal. It's just sitting down with the patient and maybe doing a mini mental status exam to determine whether they have capacity or not. And the level of capacity is going to be based, necessary is going to be based on whether it's a risky clinical trial with a new drug or if it's a survey. Also, keep in mind that just because someone has a diagnosis of Alzheimer's doesn't mean they lack capacity at all times, especially at the beginning of the disease process. So they may not do well in the evenings, but they may be fine in the mornings. So a diagnosis of Alzheimer's is not a black and white decision that this person now lacks capacity, because they may not. Same thing with a mental health diagnosis. If they have, if they're bipolar, that doesn't necessarily mean that they don't have capacity to make decisions for themselves. It's going to have to be determined on a case-by-case basis.
Okay. Can you give us just a little bit more information about durable powers of attorney versus regular power of attorney?
Sure, that can be confusing. So durable power of attorney means that that person's authority only kicks in, if you will, when the person that they're representing lacks capacity. Otherwise, it sits in a drawer and it doesn't have any power at all. A regular power of attorney, if the person that they're representing loses capacity, that power of attorney goes away. So they only have authority to act on behalf of that person as long as that person also has capacity. And I'll go back to the example of a real estate closing. I can't be there. I've got I've got capacity. I don't lack any competence to make decisions for myself, but I appoint someone else to go to that real estate closing on my behalf. They only have the authority to act for that closing. And they only have the authority to act in that closing as long as I have capacity. Again, I know it's confusing, but a power of attorney that provides that type of authority to someone is going to be a durable power of attorney.
Is there, where, if you have a proxy, where on the informed consent form are they going to sign?
They would sign on the line for the legally authorized representative. One other thing to keep in mind is if you are conducting a study and you feel certain that your subjects are going to eventually lose capacity, Alzheimer's, they may start out the study having capacity to consent for themselves, but somewhere down the road, they're going to lose that capacity. So you want to make sure that when you submit that study, that you are also requesting consent from legally authorized representative. And a line, there's a signature line. There's a template on the IRB website where the proxy would sign as the legally authorized representative.
All right. Do we have any other questions? Okay. Yeah, so, and yeah, just for clarification, so the previously, the previous session that was mentioned earlier, we don't have that recorded. That happened before we were on Zoom and recording everything.
I'm happy to give that sometime in the future.
We will definitely invite you back then. All right. Well, thank you so much for being here with us. We really, really appreciate the info. Thank all of you for being here too. And as always, if you have any questions, please feel free to reach out to us. And I hope you all have a really great rest of your day. Thank you.
Thank you.
Bye, everyone.
Bye.